Three-judge panel is hearing Utah's redistricting case in federal court. The big question of the day, does a state court have the authority to implement a new district map? Our Kade Garner finds the answers.
This hearing comes after the Utah legislature asked the state's high court to halt the recent redistricting ruling ahead of the 2026 election and instead use the state's congressional map from 2021. Cameras weren't allowed in the courtroom.
We have no interest in partisan politics. This is all about fair maps. That's what we want. That's what we will get.
But we were able to speak to attorneys from both parties as they left for the day.
I think for purposes of the Constitution, the legislature described in the Elections Clause is the legislature that sits over in the Capitol. It's not all of us.
The case, brought forward by elected officials, alleges that the decision by the Utah 3rd District Court judge to enact Utah's new congressional map was unconstitutional. It aims to stop Lieutenant Governor Deidre Henderson from implementing the new map. The panel of judges grilled the parties on three topics. 1, their standing, meaning have elected officials been harmed by the new map? 2, does the new map go against the Purcell principle, which is the doctrine stating courts should not change election rules too close to an election? And 3, merits to the claim, which again goes back to the main question. Does a state judge have the ability to impose a new map?
This is just a kitchen sink effort to, try to get the map to change, try any court. And the federal case law that this court has to consider today is clear that state courts are empowered to impose maps and have an obligation under federal law to do that.
The judges did not set a timeline for when a decision will be made, and the legislature is asking that the state Supreme Court weigh in by this Friday. Reporting from Salt Lake City, Kade Garner, ABC4 News.